council, then I'll come back with the concluding instructions, okay? Somewhere in there, when we get to that, if we get to that hour and a half time, we'll take a break, just so you know that, all right? All right, ladies and gentlemen, you have heard the evidence. The court and the jury have separate functions. You decide the disputed facts, and the court provides the instructions of law. It is your sworn duty to accept these instructions and to apply the law as it is given to you. You are not permitted to change the law, nor to apply your own conception of what you think the law should be. A criminal case begins with the filing of an indictment. The indictment informs the defendant he has been charged with offenses. The fact that it was filed may not be considered for any other purpose. The plea of not guilty is a denial of the charges and puts in issue all the essential elements of each offense. The defendant is presumed innocent until his guilt is established beyond a reasonable doubt. For each offense charged in the indictment, the defendant must be acquitted unless the state produces evidence which convinces you beyond a reasonable doubt of every essential element of that offense. Reasonable doubt is present when, after you have carefully considered and compared all the evidence, you cannot say you are firmly convinced of the truth of the charge. Reasonable doubt is a doubt based on reason and common sense. Reasonable doubt is not mere possible doubt, because everything relating to human affairs or depending on moral evidence is open to some possible or imaginary doubt. Proof beyond a reasonable doubt is proof of such character that an ordinary person would be willing to rely and act upon it in the most important of his or her own affairs. If, after a full and impartial consideration of all the evidence, you are firmly convinced of the truth of the charge, the state has proved its case beyond a reasonable doubt, and you must find the defendant guilty of that charge. If you are not firmly convinced of the truth of the charge, you must find the defendant not guilty of that charge. Evidence is all the testimony received from the witnesses, the exhibits admitted during trial, and any facts the court requires you to accept as true. Evidence may be direct or circumstantial, or both. It is the quality of the evidence that must be weighed. Quality may or may not be identical with quantity. Direct evidence is a testimony given by a witness who has seen or heard the facts to which he or she testifies. It includes exhibits admitted into evidence during the trial. Circumstantial evidence is the proof of facts or circumstances by direct evidence from which you may reasonably infer other related or connected facts which naturally and logically follow according to the common experience of mankind. If you awake in the morning and you see the ground is covered with snow, that is circumstantial evidence that it snowed earlier. If you see human footprints in the sand, that is circumstantial evidence that someone had walked there. To infer or to make an inference is to reach a reasonable conclusion of fact which you may but are not required to make from other facts which you find have been established by direct evidence. Whether an inference is made rests entirely with you. Direct evidence and circumstantial evidence are of equal weight and probative value. The evidence does not include the indictment or the opening statements or closing arguments of counsel. The opening statements and closing arguments of counsel are designed to assist you. They are not evidence. Statements or answers that were stricken by the court or which you were instructed to disregard are not evidence and must be treated as though you never heard them. You must not speculate as to why the court sustained the objection to any question or what the answer to such question might have been. You must not draw any inference or speculate on the truth of any suggestion included in a question that was not answered. You are the sole judges of the facts, the credibility of the witnesses, and the weight of the evidence. To weigh the evidence, you must consider the credibility of the witnesses. You may use the tests of truthfulness which you use in your daily lives. These tests may include, but are not limited to, the appearance of each witness upon the stand, the reasonableness of the testimony, the opportunity the witness had to see, hear, and know the things about which the witness testified, the accuracy of the witness's memory, frankness or lack of it, interest and bias, if any, together with all the facts and circumstances surrounding the testimony. By using these tests, you may assign to each witness's testimony such weight as you deem proper. You are not required to believe the testimony of any witness simply because he or she was under oath. You may believe or disbelieve all or any part of the testimony of any witness. It is your duty to decide what testimony to believe and what testimony not to believe. The testimony of one witness, if believed by you, is sufficient to prove any disputed fact. Generally, a witness may not express an opinion. However, One who follows a profession or special line of work may express her opinion because of her education, knowledge, and experience. Such testimony is admitted for whatever assistance it may provide to help you arrive at a just verdict. As with other witnesses, upon you alone rests the duty of deciding what weight should be given to the testimony of the expert. In determining its weight, you may take into consideration his skill, experience, knowledge, veracity, familiar with the facts of the case, and the usual rules for testing credibility and determining the weight to be given to the testimony. The testimony of a defendant is to be weighed by the same rules that apply to other witnesses. Police officers have testified in this case. You are not to give any greater or lesser weight to their testimony based solely on the fact that they are police officers. In count one, the defendant is charged with felonious assault. Before you can find the defendant guilty, you must find beyond a reasonable doubt that on or about the 21st day of March, 2025, and in Lake County, Ohio, the defendant knowingly caused or attempted to cause physical harm to Devin N. Quiggle by means of a deadly weapon. A person acts knowingly, regardless of purpose, when the person is aware that the person's conduct will probably cause a certain result. A person has knowledge of the circumstances when the person is aware that such circumstances probably exist. Because you cannot look into the mind of another, knowledge is determined from all the facts and circumstances in evidence. The state charges that the act of the defendant caused physical harm to person. Cause is an essential element of the offense. Cause is an act or failure to act that in a natural and continuous sequence directly produces the physical harm to person and without which it would not have occurred. Physical harm to persons means any injury, illness, or other physiological impairment regardless of its gravity or duration. Deadly weapon means any instrument, device, or thing capable of inflicting death and designed or specifically adapted for use as a weapon or possessed, carried, or used as a weapon. A deadly weapon is any instrument, device, or thing that has two characteristics. The first characteristic is that it is capable of inflicting or causing death. The second characteristic is in the alternative. Either the instrument, device, or thing was designed or specially adapted for use as a weapon, such as a gun, or it was possessed, carried, or used, in this case, as a weapon. These are questions of fact for you to decide. There is the first specification to count one. It states that if your verdict is guilty of felonious assault in count one, you will separately decide whether the state has proved beyond a reasonable doubt that the defendant had a firearm on or about his person or under his control while committing the offense of felonious assault. Firearm means any deadly weapon capable of expelling or propelling one or more projectiles by the action of an explosive or combustible propellant. Firearm includes an unloaded firearm and any firearm that is inoperable but that can be readily rendered operable. When determining whether a firearm is capable of expelling or propelling one or more projectiles by the action of an explosive or combustible propellant, the trier of fact may rely upon circumstantial evidence, including but not limited to the representations and actions of the individual exercising control over the firearm. Deadly weapon has the same meaning as above. On or about his person or under his control means that the firearm was on the defendant's person or so near the defendant as to be conveniently accessible and within the defendant's immediate physical reach. The second firearm specification of count one reads that if your verdict is guilty of felonious assault in count one, you will separately decide whether the state proved beyond a reasonable doubt that the defendant had a firearm on or about his person or under his control while committing the offense and used the firearm to facilitate the commission of the offense. The terms firearm, capable of expelling or propelling, deadly weapon, and on or about his person or under his control have the same meanings as above. There is a forfeiture specification in count one that states if your verdict is guilty on felonious assault in count one, you will also decide another issue. The state of Ohio claims that any right, title, or interest of the defendant in the Ruger LPC Max pistol, serial number 380-923-254, magazine and ammunition is subject to forfeiture to the state of Ohio. You will sign a verdict finding that the Ruger LPC Mac's pistol, magazine, and ammunition are subject to forfeiture if you unanimously find by clear and convincing evidence that each was an instrumentality that was used in the commission of the felonious assault and the use was sufficient to warrant the forfeiture of each. If your verdict is not guilty on felonious assault in count 1, you will not decide this additional issue about forfeiture. Clear and convincing evidence is evidence that produces in your mind a firm belief or conviction about the issue in question. It must be more than evidence that simply outweighs or overbalances the evidence opposed to it. Instrumentality means property that otherwise was lawful to possess, but that was used or intended to be used in the felonious assault. An instrumentality may include, but is not limited to, a firearm, a mobile instrumentality, a computer network, a computer system, computer software, a telecommunications device, money, and any other means of exchange. Firearm has the same meaning as above. In deciding whether an instrumentality was used in the commission of felonious assault in a manner sufficient to warrant its forfeiture, you must consider any of the following factors that you decide are relevant. A, whether the felonious assault could not have been committed but for the presence of the instrumentality. B, whether the defendant's primary purpose in using the instrumentality was to commit the felonious assault. And C, the extent to which the instrumentality furthered the commission of the felonious assault. In count 2, the defendant is charged with felonious assault. Before you can find the defendant guilty, you must find beyond a reasonable doubt that on or about the 21st day of March 2025 and in Lake County, Ohio, the defendant knowingly caused serious physical harm to Devin and Quiggle. Knowingly and cause have the same meanings as in count 1. Serious physical harm to persons means any of the following. A, any mental illness or condition of such gravity as would normally require hospitalization or prolonged psychiatric treatment. B, any physical harm that carries a substantial risk of death. C, any physical harm that involves some permanent incapacity, whether partial or total, or that involves some temporary, substantial incapacity. D, any physical harm that involves some permanent disfigurement, or that involves some temporary, serious disfigurement. Or E, any physical harm that involves acute pain of such duration as to result in substantial suffering, or that involves any degree of prolonged or intractable pain. There is a firearm specification to count 1. It reads that if your verdict is guilty of felonious assault, count 2, you will separately decide whether the state proved beyond a reasonable doubt that the defendant had a firearm on or about his person or under his control while committing the offense of felonious assault. The terms firearm, deadly weapon, and on or about his person or under his control have the same meanings as the first firearm specification to count 1. The second firearm specification to count 2 reads that if your verdict is guilty of felonious assault count 2, you will separately decide whether the state proved beyond a reasonable doubt that the defendant had a firearm on or about his person or under his control while committing the offense and used the firearm to facilitate the commission of the offense. The terms firearm, deadly weapon, and on or about his person or under his control have the same meanings as above. There is also a forfeiture specification to count 2. It reads that if your verdict is guilty of felonious assault in count 2, you will also decide another issue. The state of Ohio claims that any right, title, or interest of the defendant in the Ruger LPC Max pistol, serial number 380-923-254, the magazine and ammunition is subject to forfeiture to the state of Ohio. You will sign a verdict finding that the Ruger LPC Max pistol, magazine, and ammunition are subject to forfeiture if you unanimously find by clear and convincing evidence that each was an instrumentality that was used in the commission of the felonious assault, and the use was sufficient to warrant the forfeiture of each. If your verdict is not guilty on felonious assault in count 2, you will not decide this additional issue about forfeiture. Clear and convincing evidence, instrumentality, and firearm have the same meanings as in the forfeiture specification to count 1. In deciding whether an instrumentality was used in the commission of felonious assault in a manner sufficient to warrant its forfeiture, You must consider any of the following. A, whether the felonious assault could not have been committed before the presence of the instrumentality. B, whether the defendant's primary purpose in using the instrumentality was to commit the felonious assault. And C, the extent to which the instrumentality furthered the commission of the defense of furthered the commission of felonious assault. Now, a person is allowed to use deadly force in self-defense. The state must prove beyond a reasonable doubt that the defendant, when using deadly force, did not act in self-defense. To prove the defendant's use of deadly force was not in self-defense, the state must prove beyond a reasonable doubt at least one of the following. A, the defendant was at fault in creating the situation giving rise to the defendant shooting Devin N. Quiggle, or B, the defendant did not have reasonable grounds to believe that he was in immediate danger of death or great bodily harm, or C, the defendant did not have an honest belief, or even if mistaken, that he was in immediate danger of death or great bodily harm, or D, the defendant used unreasonable force. In deciding whether the state has proven beyond a reasonable doubt that the defendant did not act in self-defense, you need not be unanimous as to which of the four were proven, as long as each juror has concluded that the state has proven beyond a reasonable doubt any one of the four listed above. Deadly force means any force that carries a substantial risk that it will proximately result in the death of any person. Force means any violence, compulsion, or constraint physically exerted by any means upon or against a person or thing. Proximately result has the same meaning as cause above. The defendant did not act in self-defense if the state proved beyond a reasonable doubt that the defendant was at fault in creating the situation that resulted in the injury. The defendant was at fault if the defendant was the initial aggressor and Devin N. Quiggle did not escalate the situation by being the first to use or attempt to use deadly force, or B, the defendant provoked Devin N. Quiggle into using force. In deciding whether the defendant had reasonable grounds to believe and an honest belief that he was in immediate danger of death or great bodily harm, you must put yourself in the position of the defendant with his characteristics, his knowledge or his lack of knowledge, and under the circumstances and conditions that surrounded him at the time. You must consider the conduct of Devin N. Quiggle and decide whether his acts and words caused the defendant to reasonably and honestly believe that the defendant was about to be killed or receive great bodily harm. In determining whether the defendant, in using force in self-defense, reasonably believed that the force was necessary to prevent injury, loss, or risk to life or safety, you may not consider the possibility of retreat by the defendant. Substantial risk means a strong possibility as contrasted with a remote or even significant possibility that a certain result may occur or that certain circumstances may exist. Words alone do not justify the use of force. Resort to deadly force is not justified by abusive language, verbal threats, or other words, no matter how provocative. A person is allowed to use force that is reasonably necessary under the circumstances to protect himself from an apparent danger. If you find that the state proved beyond a reasonable doubt that the defendant used more force than reasonably necessary and that the force used was greatly disproportionate to the apparent danger, then the state proved beyond a reasonable doubt that the defendant did not act in self-defense. In deciding whether the force used was greatly disproportionate to the apparent danger, you may consider whether the force used shows revenge or a criminal purpose. If you find that the state proved beyond a reasonable doubt all of the essential elements of felonious assault in count 1 and that the state proved beyond a reasonable doubt that the defendant did not act in self-defense, you must find the defendant guilty of felonious assault in count 1 and then decide the 2 firearm specifications and the forfeiture specification to count 1. If you find the state failed to prove beyond a reasonable doubt any of the elements of felonious assault in count 1, or if you find that the state failed to prove beyond a reasonable doubt that the defendant did not act in self-defense, you must find the defendant not guilty of felonious assault in count 1, and you will not consider the specifications to count 1. If you find the state proved beyond a reasonable doubt all the essential elements of felonious assault in count 2, and that the state proved beyond a reasonable doubt the defendant did not act in self-defense, you must find the defendant guilty of felonious assault in count 2, and then decide the 2 firearm specifications and the forfeiture specification to count 2. If you find that the state failed to prove beyond a reasonable doubt any of the elements of felonious assault in count 2, or if you find that the state failed to prove beyond a reasonable doubt that the defendant did not act in self-defense, you must find the defendant not guilty of felonious assault in count 2, and you will not consider the specifications of count 1. The charges set forth in each count in the indictment constitute a separate and distinct matter. You must consider each count and the evidence applicable to each count separately, and you must state your finding as to each count uninfluenced by your verdict as to any other count. The defendant may be found guilty or not guilty of any one or all of the offense charges. It is alleged that the offenses took place on March 21, 2025. It is not necessary to state prove an offense was committed on the exact day as charged in the indictment. It is sufficient to prove that the offense took place on a date reasonably near the date claimed. You will have with you in the jury room the following verdict forms. Each states, "We, the jury, being duly impaneled and sworn, find the defendant," and then there is a blank. You will fill in either guilty or not guilty according to your findings, and then follow the instructions at the bottom of each page. There is a place for 12 signatures. Your verdict must be unanimous, and all of you must sign the verdict form in ink on the line next to your juror number. All right, counsel will now present their closing arguments. Remember, closing arguments of counsel are designed to assist you. They are not evidence. The state will go first, followed by the defense, and then the state will have the last chance to address you since they have the burden of proof.
Judge, can we approach for a moment?
Yep. Okay, all right. Couple things. The firearm in the specifications. Let's see, where is it? It's listed as an LPC, it's an LCP, correct, Ms. Tuttle?
Yes, Your
All
Honor.
right, so it's LCP, note that one change, okay? And then if you would go to page 12. In the second last paragraph on page 12, second last line, where it says defendant not guilty of felonious assault count 2, you will not consider the specifications. It should read count 2, not count 1, okay? Everybody clear on those two things? All right, Mr. Bradley, here you go. All right, thank you, counsel. Ready to go with closing arguments?
Yes, Your Honor.
Ms. Gold.
You've heard a lot of testimony over the past few days about the events that took place on March 21st, 2025. And essentially you've heard two different versions of those events, and both versions ended with the defendant shooting Devin Quiggle multiple times. As we said at the beginning of the trial, we would prove each element of each count of felonious assault, as well as that the defendant was not acting in self-defense beyond a reasonable doubt. And at this point, the state of Ohio has met that burden, and we are going to go over how that burden has been met. Now, for each of these counts, the state had to prove that they took place on March 21st, 2025, in Madison Township, Lake County, Ohio, and that David Post is the person who committed these offenses. For count 1, felonious assault, the state had to prove that the defendant knowingly caused or attempted to cause physical harm to Devin N. Quiggle by means of a deadly weapon. A person acts knowingly, regardless of purpose, when the person is aware that their conduct will probably cause a certain result or be of a certain nature. When you are pointing a firearm at someone and you pull that trigger, you are aware that pulling the trigger will cause a projectile to shoot from the firearm, and when the defendant did exactly that, he intended to shoot Devin Quiggle, which he admitted to you when he testified. Cause is an act which in a natural and continuing sequence directly produces the physical harm to another, and without it, it would not have occurred. And physical harm is any injury, illness, or other physiological impairment regardless of its gravity or duration. When the defendant shot Devin Quiggle, he caused him physical harm. And this was done by means of a deadly weapon. Now, before coming to court today and this week, you are probably aware that firearms are deadly weapons, but you also heard that from the officers who testified, and you heard that from Rebecca Silverstein-Gross, the forensic analyst, an expert on firearms. And Jordan Edgell from the Lake County Crime Lab told you that the firearm in question in this case is operable and capable of expelling or propelling one or more projectiles by the action of an explosive or combustible compel. Now, in addition to the evidence presented by the state, when the defendant testified, he admitted to you that he shot Devin Quiggle. And because these elements are not in much contention today, I will spend most of the time on self-defense. But count 2 is also felonious assault. And the state had to prove, in addition to the elements that included the date and the location, that the defendant knowingly caused serious physical harm to Devin N. Quiggle. Knowingly and caused are the same definitions that we just went over. For serious physical harm, the state had to prove that Devin Quiggle's harm consisted of a condition of such gravity that would normally require hospitalization, that it was any physical harm that carries a substantial risk of death, that it was any physical harm that involves some permanent incapacity, whether partial or total, or temporary substantial incapacity, any physical harm that involves some permanent disfigurement or that involves some temporary serious disfigurement, and any physical harm that involves acute pain of such duration as to result in substantial suffering or any degree of prolonged or intractable pain. Now, you heard from Devin as well as from multiple witnesses that he was shot multiple times, that he had to be taken to the Geneva hospital where he received some testing and then was transported via a life flight from UH Geneva to UH main campus, where he remained for 11 days. You heard from Dr. Rushing, who told you that she operated on the defendant, that a bullet was removed from his person, one from his stomach and later from his colon during 2 surgeries taking place over several different days. When Devin testified, he told you that he still has a limp, he still has nerve damage in one of his legs. In both counts 1 and 2 have firearm specifications. And this is a finding we ask you to make, that the defendant did in fact have the firearm on or about his person and under his control while committing the offense. That has been proven. He used the firearm in the commission of this offense. And the forfeiture specification you're asked to make a finding on, the finding shows that the defendant did in fact use that firearm to carry out this event, and the firearm would be forfeited to the state of Ohio. Self-defense. To prove that the defendant's use of deadly force was not in self-defense, the state has to prove beyond a reasonable doubt one of the following. And when the judge read for you the instructions about self-defense, they include a section that each of you as jurors do not have to agree on the same subsection of self-defense. If one juror believes that the defendant used unreasonable force and another juror believes that the defendant was at fault in creating the situation, you can both find that the state proved beyond a reasonable doubt that the defendant did not act in self-defense. Now, over the past few days, you've been listening to a lot of testimony about events that essentially happened in minutes, if not seconds. When it comes down to it, you have two different versions of those events. And to go over why the defendant did not act in self-defense, we have to look at both of those versions. And I'm going to ask you to assess the reasonableness of their testimony. This is the same test that you use for truthfulness in your everyday life to determine what is credible, what makes sense. Now, Devin testified that on March 21st, 2025, he saw the defendant's blue Kona. He recognized that car. He'd heard about something from his mom involving that car, so when he saw it, he wanted to figure out and confirm with his mom if that was the same car that she had previously interacted with. And that's why when Devin sees this car, as he testified, he pulls up next to it. He takes a picture, he knows his windows are tinted, he believes that the defendant will not be able to see that he is taking that picture. He pulls back behind the defendant, and that's when he takes the second picture. The defendant testified that he saw a black car with a pitch black windshield going 100 miles per hour come up behind him in the left lane. He testified that that car slowed down next to him to take a picture while he was next to him. And on cross-examination, the defendant testified that he was going between 60 and 70 miles per hour. So members of the jury, that is asking you to believe that Devin Quiggle was going 100 miles per hour and then suddenly slows down to 60 miles per hour to take a picture of the defendant. The defendant then testified that Devin forced him off the road, that Devin made a police-like tactical movement. They're both parked. The defendant is parked behind Devin about 50 to 60 yards away. And at that point, the defendant has options. The defendant can call the police, call 911, tell them someone is following me, I'm not comfortable with this. He can turn around. He can drive to a police station, make a report. He can drive a different way home. But instead, when Devin pulls out, the defendant pulls out, and they both continue driving. And it's while the defendant was sitting there, behind Devin Quiggle in what he describes a tactical maneuver, that the defendant takes his pistol out of his center console and tucks it in his abdomen waistline, what he calls an appendix carry. Next, Devin testified that the blue Kona pulled out from behind Devin into Perry One Stop. But Devin keeps driving. The blue Kona is again behind Devin. That blue Kona pulls in to the parking lot at Sammy K's, as you saw the surveillance from, but Devin keeps driving. And then again, that blue Kona gets behind Devin at the intersection of McMacken and Route 20. And that's when both the defendant and Devin are pulled up and stopped at the red light, as you saw depicted in State's Exhibit 15. Now, the defendant told you that he pulled into Perry One Stop for a few seconds to let Devin pass because he was in a hurry to get home. He told you that right before Sammy K's, Devin gestured to the defendant a yap yap or a talk talk signal. So the defendant pulled into Sammy K's for a couple of seconds to let Devin pass. And then the defendant told you that Devin started driving in the middle of two lanes. And he said, I decided at that point he won't let me go home. Devin didn't express to the defendant that Devin would not let the defendant go home. The defendant made a decision, made up his mind based off of Devin's actions. Next, Devin testified that he stuck his head out the window and he pointed to the Cleveland Clinic. And at some point you heard that Devin was yelling profanities at the defendant. He did admit to you that he did yell profanities to the defendant at some point, and the defendant did say that the victim was yelling profanities at him. The defendant told you that the victim was yelling, "Follow him home." And they both meet at the Cleveland Clinic. Members of the jury, even if you believe that Devin did say what the defendant claims he did, words do not justify force. No matter what someone says to you, you cannot use force based on words. So they pull into the Cleveland Clinic parking lot. Devin gets out of his car. He approaches the defendant. He's angry. He's yelling profanities at the defendant. But he testified that his arms are at his sides. And the defendant also pulled into the Cleveland Clinic parking lot. And when he testified, he said he pulled up in the line of fire. He said that Devin is aggressive, that Devin is making raging threats. And the defendant told you that he prepared for attack, that he knew Devin would assault him. Members of the jury, you also heard no additional evidence that Devin made any indication he was going to assault the defendant. That's something that the defendant thought was going to happen. It is not something that he knew was going to happen. So the defendant stated that he put up his left hand to stop the momentum and punched Devin with his right hand. At this point, Devin has not used any force, only words. Even aggressively yelling does not justify the use of force. And that's when Devin testified that he did a pile drive, something like a football tackle, after the defendant punched him. He said that he was leaning over the defendant and that he pulled the defendant's collar. The defendant also testified to that pile drive. He said that he had the wind knocked out of him, that Devin mounted on top of the defendant with Devin's legs in between the defendant's legs. Members of the jury, at this point in time, the defendant testified that he has both of his hands and both of his arms free. Devin is in between his legs, and the defendant has both hands and both arms free. And that's when the defendant said that Devin has an arm across the defendant's windpipe and also an arm pulling on his collar, pulling his collar out from away from his neck, creating that rip that we saw. That's when the defendant fires 2 shots and Devin tries to retreat. Devin falls to the ground. Before he fell to the ground, or at some point, a 3rd shot is fired. And Devin retreating is consistent with the hole in Devin's back. So we as the state have proven that the defendant was the initial aggressor. He is the one who punched Devin. Had he not punched Devin, this fight would not have turned physical. Devin did not escalate the situation by being the first to use or attempt to use deadly force. At no point did Devin use deadly force. At no point did Devin attempt to use deadly force. And we have proven that the defendant provoked Devin N. Quiggle into using force. Had the defendant not punched Devin, Devin never would have taken the action of picking the defendant up and doing that football tackle to the ground out of concern for his own safety. The defendant voluntarily entered this fight. He voluntarily entered the parking lot of the Cleveland Clinic. During opening statements, Mr. Bradley told you that Mr. Post finds himself in the parking lot of the Cleveland Clinic with someone he's never seen before. He doesn't just find himself there. He makes a series of decisions. He takes a series of actions. And that's where he ends up. The defendant did not have reasonable grounds to believe that he was in immediate danger of death or great bodily harm. And in deciding whether the defendant had reasonable grounds or an honest belief that he was in immediate danger, you must put yourself in the position of the defendant with his characteristics, his knowledge, or his lack of knowledge, and under the circumstances and conditions that surrounded him at the time. You must consider the conduct of Devin Quiggle and decide whether his acts and words caused the defendant to reasonably and honestly believe that the defendant was about to be killed or receive great bodily harm. And you cannot consider the possibility of retreat by the defendant. So we can look at how the defendant reacted after the shooting. In State's Exhibit 4A, you see a picture of the defendant after the shooting. You see a rip on his collar that is consistent with how Devin explained he pulled the defendant's collar away from him. This is an action that would not have been possible if Devin also had his arm across the defendant's windpipe. Brittany Loomis told you that there was blood on Devin's face and around his mouth, which is consistent with a punch in the face. In this picture, after the defendant was transported to the hospital, had a medical collar around his neck that was taken off shortly before this picture was taken. Now, after the defendant shot Devin is on the ground. Brittany Loomis arrived. She rendered aid to the defendant. Sarah Coleman, Natalie Coleman, and Sarah Kuntz also rendered aid by the time the police arrived. And that's when the defendant called 911 after Brittany Loomis arrived on the scene. In the 911 call, you heard the defendant tell the dispatcher that he removed his gun from the holster, nothing about it sliding from his waistband. Says his back hurt, says nothing about his neck hurting. Brittany Loomis testified that when she arrived on the scene and Devin is still on the ground, the defendant is calm. There is nothing about the defendant's demeanor that indicates he was just involved in an altercation. She sees no visible injuries. He looked like a bystander calling 911. Sarah Kuntz testified that he had a flat affect, that he didn't look afraid. He was just standing there. And you heard the 911 call that the defendant made.
911.
Please, I need an emergency vehicle. I was just attacked and I shot somebody.
Okay, are you injured at all?
You're fucked. My back. But the guy that I shot's on the ground.
Okay, where did you shoot him at?
McMacken Road, the Cleveland Clinic.
Okay, no,
Yes.
I'm asking on his body, where did you shoot him at?
I don't know. I was on my back. I just pulled it out of the holster and shot up. So, in
Okay.
the abdomen area.
Okay, and why is your back injured? Did you fall or what?
Because he tackled me on the ground.
Okay, where is that firearm now?
It's on my car, but two people just pulled up, and I think it's his dad, so hopefully I don't have to use it again.
Okay, I need you to keep that firearm away. There's
I
also...
got this other guy here, though.
Okay, do not touch that firearm again.
All right. Try not to.
Oh, no, it's not a try. You cannot touch it again.
If somebody pulls a firearm out on me, that be just pulled up.
What's your name?
David Post.
P-O-S-T?
Yes.
Can you tell me where the other person is that was shot?
Right on the ground behind my car.
Okay, is he talking? Is he moving?
Yeah.
Okay. Is somebody tending to him?
Yeah, there's a nurse practitioner with him right now.
What kind of car is he behind?
He's behind my blue Kona.
And you said that firearm is on your vehicle?
The firearm is on my front seat right now.
Are you inside or outside of your vehicle?
I'm outside.
Okay. Why did he tackle you?
He was been following me since Route 2. He ran me off. I pulled off the road. I come back up to McMacken here, and he was stopped at the light telling me to pull over. He said I messed with his mother a week ago, and I have no idea what he's talking about. Now he's calling me MF. But he's been messing with me coming down Route 20. I've been trying to pull off of the road. I pulled off in Sunoco Station in Perry as well.
Okay, and you're not bleeding or anything?
No, my elbows and my back hurt from being slammed on the pavement, but
Do you know what this male's name is?
I do not.
What did you shoot him with? What kind of gun?
It's a 380.
And you only shot him once?
No, twice.
Both shots hit him?
Excuse me?
Did both shots hit him?
I believe so. I fired 2 or 3 shots, I'm not sure. I just pulled the trigger, so he got off of me.
Okay. And you for sure know that the abdomen was hit?
Yes. Me, I'm right here. I got tackled on the ground. I'm with the police right now.
All right, go talk to the officers then. Keep that firearm put away.
Yep.
The defendant tells the dispatcher, I was attacked, so I shot him. The defendant tells the dispatcher, I was tackled to the ground, so I shot him. The defendant does not tell the dispatcher that he was choked, afraid for his life, that he couldn't breathe, that he thought he was going to die. During the beginning of this case, we told you that there were certain questions we wouldn't be able to provide answers to. And one of those is exactly how many times the victim was shot. Dr. Rushing, the surgeon who operated on Devin, testified that she is not able to determine which holes on Devin's body are exit wounds and which are entrance wounds. But she told you the person who would have been able to say that is a medical examiner. Thankfully, because Devin is alive, no medical examiner was needed in this case. But we do know that 3 casings were collected from the scene, States Exhibits 5A, 5B, and 5C, that a projectile fell from Devin's person as employees of the Cleveland Clinic were rendering medical aid, States Exhibit 3, that a projectile was moved from his stomach during surgery, States Exhibit 11A, and that a projectile was removed from his colon during surgery, States Exhibit 12A. We know that Devin still has bullet fragments in his arm. And we know that the projectiles causing holes 2 and 3, or defects 2 and 3, and the outermost layer were fired at close range of 1 inch or less from the testimony of Jordan Edgell. She also explained that on defect number 9 and Devin's shirt, her test revealed copper and lead, which is consistent with the passage of a projectile. We have proven that the defendant did not act in self-defense for each of these reasons listed. The defendant uses unreasonable force. It was disproportionate to the apparent danger. He did not have reasonable grounds to believe that he was in immediate danger of great bodily harm or death. He did not have an honest belief, even if mistaken, that he was in immediate danger of death or great bodily harm, and he was at fault in creating the situation. For these reasons, we ask you to find the defendant guilty on both counts. Thank you.
Thank you. Bradley? Yes, Judge, thank you. Good afternoon, everybody.
obviously, this whole case centers around the question of whether Mr. Post acted in self-defense. And as you heard the judge instruct you prior to closing arguments here, self-defense is a complete defense to both charges of felonious assault and this indictment. And when you listen to all of the testimony from Dave Post earlier today, I think it should be overwhelmingly clear that everything he did was both reasonable and in self-defense. And I think the evidence, again, is overwhelmingly clear. With that said, the law in Ohio is that we bear no burden of proof. So we don't have to prove to you beyond a reasonable doubt that Dave Post acted in self-defense, although candidly, I think it's pretty clear, overwhelmingly clear that that's exactly what happened. But we don't legally bear that burden. And it's entirely on the state of Ohio to prove just the opposite, to prove beyond a reasonable doubt that he did not act in self-defense. So in theory, if one of you ultimately, in the part of your deliberations, I'm not really sure, you know, if he acted reasonable or not, by definition, that is reasonable doubt, and the state will have failed in their burden to prove beyond a reasonable doubt it's not self-defense. When you listen to his testimony, you know, one of the things that was striking to me, at least, is, you know, his ability to recall every detail from this whole sequence of events with precision and clarity. That has to count for something. And think about this. It's Friday afternoon at 4:30. He's on his routine travel home. The only thing on his home, in his mind, is, can I hurry up and get home so I can relax and unwind from a long week? He has no idea who's in this black car. He has no idea who Devin Quiggle is. So the notion that, you'll recall Devin's testimony, is that he is just minding his own business and driving home, and that it's Dave Post who flies up on him, that makes no sense. He has no idea who who Devin Quiggle is. He has no idea whose car that is. Contrast that with, it's apparent that Devin Quiggle had talked to his mom a week or so before, whenever it was, who told him about some encounter with Dave and his somewhat unique blue car with the veteran's plates. And he's the one who took the pictures, messaged those to his mom, called him and said, "Is this the guy?" So right away, in this whole sequence of events that took place on Route 2 until we get to the Cleveland Clinic parking lot, right away, when you hear both of these versions of the events, it should be clear that what Devin and vicariously the state of Ohio are suggesting is categorically false. There's just no way that he's creating the problem here. How could he? He doesn't even know who Devin Quiggle is. And in fact, it's just the opposite. He suspects that this is the guy that was messing with his mom a week earlier, and he wants to, in so many words, exact revenge. And that's why everything you heard Dave describe to you in detail, flying up from behind, running parallel and taking his picture, pushing him off the road, driving from Route 2 into Route 20, pulling over into the Sunoco gas station and then later the Sammy K's. I mean, think about this. Why would, if it's what the state would suggest and he's trying to create a problem here, why is he pulling off into these two locations while Quiggle continues to drive on? Why would he do that? In fact, just the opposite. He's trying to avoid an encounter with Devin Quiggle. Now you can say in hindsight, well, I mean, look at the, the videos aren't evidence, you can take a look. So he pulls into the Sunoco station, and from the time he pulls in until the time he pulls out is like 36 seconds or something. And clearly, if he would have, in theory, stayed there for 3 or 4 minutes, or 5 or 6 minutes, then in theory, he would have never caught up to Quiggle's car, never had this whole encounter. So, yeah, you could look in hindsight and say, well, gosh, you could have avoided all of this if you would have just stayed there longer. But he's not wrong for trying to avoid this, and he doesn't forfeit his right to act in self-defense because he was only in that parking lot for 36 seconds as opposed to 5 minutes. He doesn't know that, 10 minutes from that moment, he's gonna find himself in a parking lot with this guy on top of him. And you could say in hindsight, well, gosh, couldn't you have just called 911? I mean, maybe in hindsight, couldn't he have went into the Sunoco station or Sammy K's and said, hey man, there's this guy that's following me and creating me these problems. Again, maybe, but he didn't. And so what? What is the point? And the state stands before you and makes these arguments that fast forward 10 minutes later and he's on the ground with this guy choking him out, that he's forfeited his right to act in self-defense because he should have called 911? That's crazy. And then ultimately, when they end up at that intersection at Route 20 and McMacken Road, this is now the 3rd time that he's yelling out his window, screaming profanities. I'm gonna F you up. You're messing with my mom. So, and he admits that. And Jeff Gerson doesn't hear exactly what Jeff, being the owner of the tire shop that's right at that intersection, he hears this encounter. He doesn't hear exactly what he's saying, but it's noteworthy enough that he leaves his office and steps out and sees what's occurring here. Devin admits that he's yelling these things out to him. You heard Dave testify that as they're heading up to that intersection, that he's engaging in these S-type maneuvers that would prevent him from getting around Quiggle's car. And when I asked Devin about that, his response was something to the effect of, I can either confirm or deny, something like that. Which is a ridiculous answer that you can assume by that answer that that's exactly what he did. So, number one, think about what that means. Why is, at multiple stoplights, why is he, first of all, sending his pictures of Post's car to his mom? Why is he doing that? Why on multiple stoplights is he rolling down his window and screaming at this guy? Why is he engaging in these S maneuvers? Why is he doing it? Because he wants a confrontation. Not the other way around. He wants a confrontation. And then ultimately they turn left onto McMacken Road. And again, you could ask yourself the question, well, God, if you would have just kept going straight down McMacken, might you have avoided this whole confrontation? And the answer is maybe. Maybe. But he didn't, and he told you why not. One, I only live 3.2 miles from there. I don't want this guy pulling out, following me at home, and now he knows where I live. And two, I'm confused. You've been messing with me for the last 20 minutes, screaming things at me. Who are you? What do you want? And so he made that choice to follow him in there. In hindsight, coulda, woulda, shoulda, sure, maybe. But he didn't. And what? Because he didn't, again, he forfeits his right to act in self-defense? Of course not. So then he pulls in, and he tells you that he doesn't pull right up next to Quiggle's car. Why not, Dave? I didn't want him to, one, perceive me as a physical threat. I'm not a threat. And two, to keep distance between us. Because he's not sure who this guy is and what he wants. And so when he gets out of the car, he stays right by his driver's side door. And then it's Quiggle who comes at him. And this notion, the prosecution wants to say, words alone cannot justify use of force. Well, that's true, because he instructed you that's true. But this isn't just words. This is all of the events that started back on Route 2, all the way up at the stoplights, et cetera, the intersection of McMacken and 20, all of that behavior and conduct, all of the rage that he described that Quiggle was demonstrating, his aggressive behavior in coming over to his car, his words combined with that aggressive behavior, I'm gonna fuck you up. And he's coming to post. And then when he comes right around that corner of the car and he puts his left arm up and on his chest, and Quiggle doesn't stop coming, yes, he punched him. He's justified in doing that. That is not words alone. He is legally justified to defend himself. He does not have to wait until Quiggle tackles him to the ground, or Quiggle punches him, or Quiggle does whatever physical to him. He does not have to do that. You have to reject the state's argument that that's words alone. Somehow place the blame on him that he's at fault. Wrong. Do not accept that argument. That is false. That is not what Ohio law says. So he is totally justified in defending himself in that situation. And what he did was totally reasonable. So he punches the guy. And then what Quiggle did was escalate the situation. Pile drived him in to the pavement. A classic football move, he says. And so there's a slight difference, at least in my mind, in Quiggle's. A tackle is a tackle. A pile drive's different. You're grabbing somebody around the waist and lifting them up off the ground and forcing them into the pavement. And just think about that. And it's all happening fast. And can you imagine getting slammed into the pavement? And I say this nicely because I'm not much younger than this guy, he's 63 years old. Quiggle's 25 years old. And they want to portray him as some frail kid? No. Former football player, let's start with that. Moves furniture for a living. So, yes, he has injuries now. It's terrible and tragic that he does. And I'm sure he feels that now. But in that moment, when the guy's in a rage, exacting revenge for his mom, and slamming him into the ground. Can you imagine the impact of that? And you heard it. Knocked the wind out of me. My head hit the back of the pavement. I was disoriented. And then at that point, he's got his forearm against this windpipe. So, I mean, again, imagine what's going through Dave Post's mind. How did this escalate so quickly? What's going on? You know, we talk about this over the course of, an hour and a half of direct examination. This is happening in seconds. He doesn't have the time to take a time out and let me think this through. He's reacting in the moment. And he tries to get out from under him, and he can't. And then he feels his gun come out, and you heard Dave say, we both, for that split second, looked down and saw that gun. And he admitted it, Quiggle did. Remember I asked him, I said, you told the police during your interview that you saw the gun for a split second. It was down by his little pecker. And Quiggle said, I've never used that sort of language. And then he listens to his recording and say, Devin, does that refresh your memory that you exactly said that? Yes, it did refresh my memory, and I did say that. So imagine now. He's getting choked out, and Post sees that Quiggle sees his gun there, and he can't otherwise escape. So he is totally justified in using deadly force in that situation. That is the law. That is self-defense. Now the prosecution wants to say, he acted unreasonably. This was an unreasonable use of force. He brought a gun to a fist fight. This wasn't a fist fight. He's down on the ground, getting choked, and has reasonable belief that this guy's going to grab his gun and shoot himself with his own gun. And let me pause here and say, it's a really, really important piece of evidence. You heard Jordan Edgell. She's the woman from the crime lab. She's the one who examined the various articles of clothing. And the outer clothing, the Carhartt hoodie, and you'll have that in evidence. And she talked about how she's able to forensically examine that and conclude that the 2 shots into his left arm were contact or close to contact. Close to contact meaning an inch or less. Okay? So that gun is either literally touching that sleeve of his left arm or an inch away. Okay? And so 2 scenarios. One is the scenario that Dave Post described to you, where he's laying on the ground, Quiggle's on top of him, got his forearm against his throat, and Dave takes the gun in his right hand and shoots into his left arm twice. And that's what causes one bullet to go through and through and cause this almost like skipping a rock over the pond, this injury right across this chest. Because it went in the arm, across this chest. And that's in the medical records. You've got those, you can look at it. That would be entirely consistent with Dave Post's description of what occurred. Now compare that to what Devin told you. What Devin said is, yes, I pile drived him to the ground, and then I was standing over him. That was the whole point of me getting down on the ground here, to make sure it was crystal clear to each one of you. So there was no misunderstanding of his description of what took place in that critical moment when the shots were fired. And so what he says is that Dave is on the ground and sitting up, and that he's standing over him. He showed you. He said it, and he showed you, okay? How in the world could then he have had 2 contact or close to contact wounds into his left arm, and that would have went one across the chest? How can that be? And the answer is, it can't be. It's physically impossible. And why is that so significant? Because he took that witness stand, took an oath, looked at each and every one of you in the eyes, and lied right to your face. Lie is a pretty strong word, okay? If I think it's Wednesday and I tell you it's Thursday, or if I think it's Wednesday, but in fact it's Thursday, I'm not lying. I'm mistaken. I'm wrong. Oh, my bad. I got confused on my days. But if I know it's Wednesday and I tell you it's Thursday, I'm lying to you. It's a big difference. And when he takes the witness stand in a serious case, this is a shooting incident, and takes an oath and looks at you and lies, what does that tell you? Frankly, all you need to know. He lied to you. There's no other way to spin it. It's crystal clear. He says, I'm standing there over him. If he shoots when he's standing up, think about, first of all, the trajectory of the bullet, this way. And we know, in fact, the trajectory of the bullet is this way. And second of all, unless he's got rubber man arms, there's no way that he could be on the ground sitting up, Quiggle standing over him, and it'd be contact or close to contact. So you just on that fact alone, you should recognize that Quiggle is lying to you, and you should reject his testimony. Because the state bears the burden of proof beyond a reasonable doubt that it's not self-defense, one of the things that they have to prove beyond a reasonable doubt that he being Dave Post, was not the initial aggressor. And they want to maintain that because he threw the first punch, he was the initial aggressor, and therefore not entitled to self-defense. But for all of those reasons I just said, that really misses the mark. He's not the initial aggressor. When he throws the first punch, he's defending himself. And he's allowed to defend himself because it's not just words, it's the words together with the conduct of Devin Quiggle up to that point. So it's pretty clear when you consider the totality of these circumstances, as you're required to do, that he was not the initial aggressor, going all the way back to when he's on Route 2. From that point forward, every step of the way, it's Quiggle that's the aggressor, not the other way around. And then the honest and sincere belief that he's in imminent, immediate danger of harm. Again, that's so obvious. Imagine a scenario where you've been slammed to the ground and you got some guy that's not even half your age on top of you, choking you out. What would you think? And the fear that he's going to take my own gun and use it against me. So is that an honest and sincere belief? Of course it is. You heard it from his own mouth. Why did you do this, Dave? because I was afraid of what this guy was gonna do. The unreasonable use of force. Again, work through this slowly. There's kind of two separate incidents of force. The first one being the punch, and the second being the shots. And I won't repeat myself too much here, but the whole punch is legally justified because of all of the conduct and words up to that point. So he's justified in using non-deadly force, i.e. a punch, in response to Quiggle's threats. And then once he's on the ground, can't get out from under him, and being choked, and fearful that this guy's now sees and knows I've got a gun, he's gonna take it and shoot me. What else could he do under the circumstances? He doesn't have to wait until he sees Quiggle get the gun and then try and wrestle it from him. Of course not. One other thing I forgot, back to the question of, was Quiggle lying to you? And the whole he's standing over you and, well, 2 shots into the left arm, contact, there you go, right? But there was also the testimony of Angela Sakarik. She was one of the nurses that was, I think she said 100 feet away in the parking lot and talking to a coworker that was in the truck and heard some yelling. Saw the 2 guys pull in, heard them yelling, saw them start fighting, and then said to her coworker, hey, should we call 911 here? And then ultimately turns and sees them on the ground. Now, she said, I couldn't tell who was on top and who was on bottom. Fine, that's not the point. The point is, she saw them on the ground. One was on top of the other. But Quiggle totally denied that. So besides the whole notion of the contact or close to contact shots into the arm, which in and of itself proves he's lying to you, Angela Garrett basically proves to you that he's lying to you when he says, no, I wasn't on the ground, I was standing over. And you've got to ask yourself, what would be his motives in lying to you? Because he wants to create this impression or image in your mind that, hey, I tackled him to the ground because he punched me for no reason, and then he leans up while I'm standing over and just starts shooting away. That's what he wants to try and pitch to you. And vicariously, that's what the state wants to pitch to you. That he acted unreasonably, that he brought a gun to a fist fight. That's all this was. And that he was laying on the ground, sat up, and boom, starts blowing him away. But we know that's not the case. And just another reason why you should reject the state's arguments and find that he did, in fact, overwhelmingly clear evidence that he acted in self-defense. And listen to the 911 call. We've heard it now several times. And when the prosecutor played it in her closing argument, I'm thinking to myself, thank you. Thank you for playing that 911 call in closing argument. I think you've heard it now 3 times. You heard it initially, we played it through post-testimony, and you just heard it in closing argument. You're going to have it in evidence. And I'm saying, please listen to it 1 more time. 2 more times. Because imagine the stress of that situation. Whether you acted in self-defense or not, the adrenaline rush. You shot a gun and shot somebody. And then you pick up the phone at 911. You've got no time or ability to let that adrenaline drain out of you and stuff. There's a certain inherent reliability in what somebody says in a 911 call because they're generally calling in response to an emergency, and they don't have time to process things. So there's a certain inherent truthfulness and trustworthiness in what somebody says in a 911 call. And listen to that 911 call and listen to what he says. I was on the ground. Let's start with that. He was tackled me to the ground. I was on the ground when I shot, not sitting up. I was on the ground. I fired 2 to 3 shots. I shot until he got off of me. Let those words resonate when you deliberate this case. There it is, right? I pulled the trigger and shot until he got off of me. Right there, what he's really saying is, I shot in self-defense. He doesn't use those words, but I shot until he got off of me. And the notion that, well, he didn't go on and say, he choked me, or I hit the back of my head, or whatever other details that were not included. Well, because you're in the stress of the moment. So 2 hugely important pieces of evidence, the 911 call and Jordan Edgel's testimony about the contact or close contact shots to the left arm. One other, I'm just looking at a few notes from the prosecutor's comments and closing argument, that, well, you heard Devin say he didn't know that Dave Post didn't know that Devin Quiggle was going to choke him out or attack him. He just believed it. Well, of course. None of us know what's going to happen a minute from now. And it's right in the instructions. They say reasonable grounds to believe that he was in immediate danger. Okay? So now you don't have to know. You can't, I got to predict the future. It's right in the instructions. It's what he believed. And when you listen to all of his testimony, is there any doubt that Dave Post was honest in telling you exactly what he believed in those moments? It is scary to sit in that seat. There's 40 people in this courtroom here, but this is the hot seat. Nobody wants to sit in that seat. And this is undoubtedly the single most important event in Dave Post's life. And he took that witness stand and told you exactly what was going through his mind when he fired those shots. And it should be overwhelmingly clear that this guy was not looking for a confrontation on his way home from work on a Friday afternoon. And that everything he did was reasonable and in self-defense. And for all of those reasons, you should reject the prosecution's calls to convict him, and instead find him not guilty of both of these counts of felonious assault. And with that, I thank you for your time and attention.
All right, thank you, ladies and gentlemen. I'll give you about
client could remember details about what happened and the precision with which he could testify to them. But it's convenient that those details that he remembered can't be verified by any other means. It's convenient that those incidents he recalled to you weren't reported on his 911 call. It's convenient that those things happened just feet away from the camera view. The defendant testified, but he told you things that didn't make sense. He told you this fantasy story of wild things that happened, of being run off the side of the highway with a police-like maneuver, sitting on the side of the road for 2 minutes, nobody moving, just sitting in their cars. He places a loaded gun in his waistband at this point because something's gonna happen. Then he calmly drives back onto Route 2, following the car that allegedly ran him off using police maneuvers. No one called 911 to report this. It didn't happen. Every story that the defendant told us going down that road, there's no way to verify that. The defendant tells us that just feet before we get to the security footage that we have at Northridge Automotive, that Devin Quiggle slams on his brakes and is going 5 to 10 miles per hour, driving in an S shape for 40 to 50 feet. Then conveniently, we get to where the security footage picks up. Members of the jury, you have that. That's Exhibit 15. You see Devin Quiggle driving at a normal rate of speed. That camera footage comes from Northridge Automotive, where the defendant said, just to the left, they're stopped dead. You see the defendant fly up behind Devin to that light, and you see him park right behind him. You hear what the defendant does there. He opens his car door. He told you that. You see it on the video. He puts a leg out of the car, and he begins screaming at Devin Quiggle. Devin didn't shy away from the fact that he was upset. He was followed, members of the jury. You'll have that video footage. You saw that video footage at every single turn. The defendant is behind Devin Quiggle. The defendant wants you to believe that he's scared, that this guy's bothering him, that the black car is causing problems. The only one causing problems or following anyone down Route 2 or Route 20 is the defendant. Now, the reason we introduced that evidence to you isn't to say that he forfeits his right to self-defense. That's not at all what we as the state of Ohio are saying, that because he acted irrationally on the highway, he forfeited his right to self-defense. But members of the jury, it paints a clear picture of the defendant's mental state the entirety of March 21st. Somebody took a picture of his car. You heard Devin was side by side with him. He took a picture. You heard the reason why he took that picture. His mom had some sort of harassment by this car previously. He's trying to figure out if it's the same person, so he takes a picture of the driver. You then heard that he gets himself behind that car. Devin falls behind and he takes a picture of the plate. He told you that he was sending them to his mom to see if A, it's the guy, and to say, B, we've got a plate now, so maybe we can report this, right? That's why he did it. But the defendant wasn't having anything of it. That car did something wrong to him, and he was going to follow. There's zero evidence that the defendant was run off the road on Route 2. There is zero evidence that he was stopped on the side of the road. There's zero evidence that a police-like tactic maneuver was performed on his vehicle. It didn't happen. Driving down the highway, turns into Route 20. You see the defendant pull off at the Perry 1 stop. Mr. Bradley asked, why would he do this? We don't know why, members of the jury. He's not acting rationally. If it's for the reasons that he said, he would have acted differently. If the defendant is truly trying to escape Devin Quiggle, he would have stopped for more than a few seconds. He would have called 911. He would have done something other than just drive in and drive out. It is an irrational act performed by somebody who can't keep it together that day. When they get to the Sammy case, that's about 4 miles down the road. You see, the defendant catches up pretty quickly. He told you all, he caught up quickly. Did he turn? No. Did he call 911? No. He's driving with a loaded gun in his pants instead, following this car at close range. He pulls into Sammy case for seconds and pulls back out. Why? It was irrational. It accomplished nothing, and it's not consistent with what the defendant told you his purpose was. He knew there was a light just ahead. He pulls out. The car he was stopping to get away from is at that light. But when I asked him, why didn't you change your route home? He was going home his way, no matter what. And what was so important, members of the jury? It was Friday. That's it. The defendant's driving with a loaded gun in his pants, swerving in and out of parking lots, coming up around cars because it's a Friday. He's not acting rationally. Nothing he did was rational that day. Now, the defendant admits to every element of felonious assault, and he admits to the necessary findings for those firearm specifications. We have met our burden in proving to you beyond a reasonable doubt that he knowingly caused serious physical harm to Devin Quiggle, and that he knowingly caused physical harm to Devin Quiggle with a deadly weapon. But for that firearm, he would not have been able to cause the harm that he did to Devin. So I'm not going to focus on those elements. I'm only going to focus on self-defense here because that's the question. And like we've explained all along, self-defense is a complete defense to felonious assault. So it's essential that you, as the jury, look objectively at what's going on here. Mr. Bradley told you, clear as day, overwhelming evidence, self-defense. Well, that's his job to say that, members of the jury. Your job is to look at this from an objective third-party standard. And as you saw, this didn't happen to him. It wasn't an accident. You heard him testify that as he was coming down Route 20 toward McMacken, he says, I'm stopping in the Cleveland Clinic parking lot. No matter what, that's my place, I'm stopping. He gets out of his car, he hears Devin yelling, he's yelling back, both are yelling in person. The defendant is a participant in the yelling in person. He says, pull into the parking lot. Devin says, pull into the parking lot. There's a meeting of the minds. He knows what he's going there for with his loaded firearm in his pants. They pull in. And members of the jury, some of the evidence here was mischaracterized. I'm going to clarify for you what the testimony was that we actually heard. You heard that Devin had his arms at his sides. He's screaming and yelling, and he's moving across the parking lot. That's his conduct. That is it. That's what he's doing. You heard the defendant. He said his car is about as high as his head. So he sees Devin moving, but nothing else. He didn't see arms raised. He didn't see fists in the air. He didn't see a weapon. Nothing. He sees someone coming toward him. But the defendant is hiding behind his car. He's hiding behind the corner here. He waits for Devin Quiggle to come around, and you heard him testify that as Devin turned the corner, he sticks his hand out and punches him. This isn't a stop, 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 and Devin keeps pushing. The way he testified was, as he turned the corner, I put my left hand out to stop him and threw a punch with the right. He doesn't even give Devin a chance. You heard Devin's testimony that he went over there to argue. His hands were down. He wasn't in a defensive or offensive position, and he was completely caught off guard by being punched in the face. If Devin was going over there intending to attack the defendant, his arms would have been up like this. He wouldn't have gotten hit in the face because his hands would be ready to punch. He would have been ready to attack. So what we had was words. We had threats, the defendant says, but members of the jury, words, as offensive as they may be, are not enough to justify the use of force. The defendant was the initial aggressor. He took matters into his own hands. He used the element of surprise and punched Devin in the face. The physical evidence on Devin's body corroborates that. The defense forgets here that Devin's body is a great source of physical evidence. It's a source that you all should look at, and it's a source that directly conflicts with everything Mr. Post says. Devin, from the beginning, has admitted to tackling Mr. Post in a style where he lifted him up and he put him on the ground. This is non-deadly force. It's non-deadly force in response to being punched in the face. Also non-deadly force. The defendant escalates an argument to a fist fight. Devin defends himself in that fist fight. Now, here is where Mr. Bradley mischaracterized what Devin told you. Devin didn't lie. But Mr. Bradley didn't tell you everything he said. When Mr. Bradley was down here laying on the floor, he asked Devin to come down and stand where he was standing. So Mr. Bradley's laying on the ground and Devin's standing. He didn't say, lean over and show me how you were grabbing his collar. No. He said, show me how you were standing. And then he said, show me how the defendant sat up. But he never said, lean over and show me how you were pulling on his collar. Members of the jury, you heard that after he tackled him, Devin was down like this, bending over the defendant, hand on his collar, pulling up. That's where the rip came from. The physical evidence corroborates Devin's positioning. He's completely bent over, standing up, not on his knees, but completely bent over the defendant. That was his testimony when asked how this unfolded. When asked when he saw the gun, he said for a split second, as the defendant was pulling it to shoot. So yeah, he saw it before he got shot because the defendant used his left hand to lift the right side of his shirt, pull a gun out of a holster, and shoot him. Devin testified that at that point, he's bent over hand on collar and trying to retreat. It's consistent with him being shot at or near contact because Devin told you he's leaning over the defendant. His hand's not on his windpipe. His hand is pulling up on that shirt. And the defect on that shirt, that rip on the collar, that's consistent with force pulling up. The defendant wants you to believe that he is simultaneously pulling hard enough to rip his shirt and pushing hard enough to stop him from breathing. He wants you to believe that 140 pounds of Devin Quibble is between his legs, legs free, arms free, Devin's left arm's free, that Devin's using one arm to do all of this harm. The force of one arm from a 140-pound 24-year-old against the defendant, that is not deadly force. That's not even close to deadly force. And that is all that the defendant told you happened. That Devin Quibble used one arm. He didn't tell the 911 operator that he couldn't breathe because he could. He didn't tell the 911 operator that he was in fear for his life because he wasn't. You heard how he responded after this. You heard what he looked like. The people that first responded to this scene before he even picked up the phone to call 911, Brittany Loomis, says she thought Devin got hit by a car. When she asked what happened, Devin said, I was shot. She said, who shot you? The defendant's standing there. He says, that guy. She was shocked. The defendant didn't look like he had just fought for his life. The defendant didn't look like he was in any fear. You heard from Sarah Kuntz, the nurse that came outside to render aid. Sarah and Brittany both heard the defendant yelling at Devin as he laid there on the ground. He tells you, I didn't say anything. I immediately made a 911 call, and then the police came and arrested me. There was time that elapsed before that 911 call. Time where independent witnesses say he was screaming and yelling at Devin Quiggle. The whole time that Devin's being read, the defendant is standing there, calm as a cucumber. He's not acting rationally. He's not acting like somebody who just fought for their life, who couldn't breathe. And you heard the contents of that 911 call. I was tackled, so I shot him. Tackle, shooting. Non-deadly force in response to being punched in the face. Shooting. Let's talk about those wounds to Devin. There was an unreasonable use of force here. Members of the jury, you'll have Devin's medical records. And in those medical records are some pictures of some of the wounds. Now, Ms. Gold did misspeak previously during closing arguments, but Devin had 2 bullets removed from his body. One was removed from his colon, and one was removed from that left arm. The bullet holes that we know exist in Devin. Left shoulder, left arm, graze wound across chest near his sternum, hole in his right armpit, and a hole in the center of his back. It's the defendant's contention that he shot 2, maybe 3 times. It can't be true. That can't be it. With the way that Devin's body is, the bullets that are recovered, and the holes that exist on him. This is the hole in Devin's armpit. You heard the doctor testify that she can't tell you if that's an entry or exit. We need a medical examiner. Thank God Devin's alive. We'd rather have him alive than that information. Can we go to the next photo? This is that graze wound. She was able to say that this is something going in and coming right back out. That's the wound on his chest. You can show the next one. That is the hole in the center of Devin Quiggle's back. The way that these shots are fired at him are consistent with his story that he turned to retreat. They're not consistent with the defendant's story saying, I was on the ground, I shot twice, and then I rolled a little bit, and then I shot again. No. The bullets that are recovered, one is recovered from the arm. That's a whole bullet. Got an answer for that. The graze wound. We have a bullet that falls out of his clothes at the scene. Guess there's an answer for that. What we have left is a bullet found in Devin's colon, a hole in his back, a hole in his side, a hole in his arm. There were more than 3 shots fired. You heard Detective McClure testify that we don't like it, but it's reality. These bullet casings roll away. They get stepped on. Things happen. They're lightweight and they move. Crime scenes are created by the people who create the crimes. They're not created in a vacuum. They're not perfect. You heard how many people were in and out of this crime scene before it was secured. You heard how many medical professionals attended to Devin before the police even arrived. We had a nurse practitioner, we had nurses coming out from the Cleveland Clinic, then the police get there, it's not taped off yet, but you got EMTs arriving, we have 2 different police departments. Unfortunately, we can't always collect every single piece of evidence. But the defense discounts Devin's body, and we learn a lot from it. The defendant told us that he shot him in the left arm first, at or near contact. The graze wound. He had to have been turning. A wound here and a wound here. Can't tell you where exactly Devin was shot. He can't tell you where he was shot. Devin had a reason for why he might not have the clearest memory of what happened to him. Devin was shot repeatedly by the defendant. Devin was life flighted. Devin had 2 life-saving surgeries performed on him. Devin had a rod put in his arm. Devin had half of his colon taken out. Devin has permanent nerve damage to his leg. Devin fractured his back. Members of the jury, saw the damage caused by force Devin used against the defendant. The police took that seriously, took him to the hospital. What do we see? Scrapes, redness, and aggravation of a pre-existing injury. That's it. The defense wants you to think that Devin overpowered the defendant, that Devin is stronger than this man, that Devin is faster than this man, that Devin is way not a match for him. But you saw them both here in the courtroom. You heard how big they are. Devin, 5'9", 140. The defendant, 5'8", 168. You heard what they both do for a living. At the time, Devin delivered furniture. The defendant is a bus mechanic. This isn't a mismatch of power. This isn't a mismatch of size. The defendant is not some feeble old man. The defendant himself told you, I'm in good shape. And he was in good shape on the day that this happened. Members of the jury, that 911 call is really important. It's important because the defendant gets specific. I was tackled. Not, I thought I was going to die. Not, I was choked. Not, I'm in fear for my life. Now, 10 months later, he was choked, he was tackled, he was in fear for his life. That's not what he told the dispatcher when this was fresh in his mind. And when he was up here testifying, he said, the back pain is why I didn't say that. Because I was tackled and had the back pain. I didn't tell him I thought I was gonna die. All the defendant could think about was his anger that he was tackled. There is zero evidence that Devin Quiggle was ever reaching for that firearm. The defendant's weapon wasn't going to be used against him because Devin didn't know he had it until it was too late. And that's when Devin tried to run. Devin didn't blind you. But the defendant told you a lot of things that can't be corroborated by anybody else. Devin responded to force. The defendant escalated that force at every turn that he could. He wasn't in fear for his life. He was the one looking to do something. That's why he put that loaded gun in his waistband long before he ever made it to that parking lot. That's why he had the element of the surprise behind his car to punch Devin in the face. And that's why he was ready to pull that gun as soon as he thought he could say he was justified. Because of these reasons, we have proven to you beyond a reasonable doubt that he did not act in self-defense. And we ask that you find the defendant, David Post, guilty of felonious assault in both counts with all of the accompanying firearm and forfeiture specifications. Because he knew what he was doing, he wasn't afraid, and he shot someone for a fight that he voluntarily entered and escalated. Thank you.
Thank you. All right, ladies and gentlemen, we'll pick up back on page 13 for the concluding instructions. court cannot embody all the law in any single part of these instructions. In considering one portion, you must consider it in light of and in harmony with all the instructions. The court has instructed you on all the law necessary for your deliberations. Whether or not certain instructions are applicable may depend upon the conclusions you reach on the facts. If you have an impression that the court has indicated how any disputed fact should be decided, you must put aside such an impression because that decision must be made by you based solely upon the facts presented to you in this courtroom. You may not discuss or consider the subject of punishment. In the event you find the defendant guilty, the duty to determine the punishment is placed by law upon the court. Circumstances in the case may arouse sympathy. Sympathy is a common human emotion. The law does not expect you to be free of such normal reactions. However, the law and your oath as jurors require you to disregard sympathy and not to permit it to influence your verdict. You must not be influenced by any consideration of sympathy or prejudice. It is your duty to carefully weigh the evidence, to decide all disputed questions of fact, to apply the instructions of the court to your findings, and to render your verdict accordingly. In fulfilling your duty, your efforts must be to arrive at a just verdict. Consider all the evidence and make your finding with intelligence and impartiality and without bias, sympathy, or prejudice, so the state and the defendant will feel that their case was fairly and impartially tried. If during the course of the trial the court said or did anything that you consider an indication of the court's view on the facts, you are instructed to disregard it. When you go to the jury room, your first function will be to select one of your number to serve as a foreman. The person you select to preside over your deliberations does not have any greater power, nor does that person's vote have any more importance than any other jurors. He or she serves the purpose of helping to conduct your deliberations in an orderly manner and to give each of you the opportunity to express your opinion. One additional duty of the foreperson is to see to it that the verdict forms and exhibits are returned to the court after you have reached a verdict. If you took notes during the trial, you may take your notes to the jury room. The fact that the notes taken by a juror support his or her recollection in no way makes his or her memory more reliable than that of the jurors who do not take notes. All notes will be returned to the bailiff for destruction when the jury is discharged. The court will place in your possession the exhibits, a copy of the jury instructions, and the verdict forms. The foreperson will retain possession of those records, including the verdict, and return them to the courtroom. The foreperson will see to it that your discussions are orderly and that each juror has the opportunity to discuss the case and to cast his or her vote. Otherwise, the authority of the foreperson is the same as any other juror. Until your verdict is announced in open court, you are not to disclose to anyone else the status of your deliberations or the nature of your verdict. Your initial conduct upon entering the jury room is a matter of importance. It is not wise to immediately express a determination to insist upon a certain verdict, because if your sense of pride is aroused, you may hesitate to change your position, even if you later decide you are wrong. Consult with one another, consider each other's views, and deliberate with the objective of reaching an agreement, if you can do so without disturbing your individual judgment. Each of you must decide this case for yourself, but you should do so only after a discussion and consideration of the case with your fellow jurors. Do not hesitate to change an opinion if convinced that it is wrong. However, you should not surrender honest convictions in order to be congenial or to reach a verdict solely because of the opinion of other jurors. In order to return a verdict, it is necessary that all jurors agree. Your verdict must be unanimous. Your verdict must be based solely on the evidence and on the law as the court has given it to you in these instructions. Nothing the court has said or done is intended to suggest what your verdict should be. That is entirely for you to decide. If you have any question or request during your deliberations, your foreperson should write that question or request on a paper and notify the bailiff so the question or request can be delivered to me. The court cautions you, however, with regard to any message or questions you might send, that you should not reveal your numerical division at the time or the status of your deliberations. It should be reduced to writing so there will be no misunderstanding as to what you request. It should then be delivered to the bailiff, who will submit it to the court. Whenever all 12 jurors agree upon a verdict, you will sign the verdict in ink and advise the bailiff by using the bell in the jury room. You would then be returned to the courtroom. As mentioned earlier, you have heard all the evidence. It is common practice when jurors commence deliberation to request transcripts of various witnesses. There are no transcripts. Juror number 12, you were selected to serve in the event of any misfortune to any member of the panel. At this point, you will no longer accompany the jury to the jury room or participate in deliberations unless directed by the court. Please remain in the courthouse until the court directs you that it will not be necessary for you to serve any further. You are not to discuss the case or tell anyone else how you would have voted until after the jury has returned a verdict. After you are discharged, you may discuss your verdict and your deliberations with others, but you are not required to do so. You must decide for yourself whether or not you will discuss such matters. It is the lawyer's duty to protect your desire not to talk about the case if that is your decision. It is improper and unethical for a lawyer or anyone else to harass, entice, or exert improper influence upon you for the purpose of getting you to talk about the case. Once 12 members of the jury have agreed to a verdict on each of the counts and have signed the corresponding verdict forms, the foreperson will notify the bailiff and you will be returned to the courtroom. Anything else with regard to these instructions from the state?
No, Your Honor, thank you.
From the defense?
No, Your Honor.
All right.